So welcome everybody to our Advisors Forum webinar today about supported decision making presented by Elville & Associates President and Principal Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director at Elville & Associates, and I'll be moderating today's event. Steve and I, along with everyone here at the firm, hope you're faring well during these times. It's good to see things opening up a bit. We thank you for taking time out of your day to be part of our event. How this will work today, you are on mute. However, if you have questions, and we really want to encourage questions throughout, please note them in the box on the right-hand portion of your screen, and we will take time throughout the presentation to address your questions. You received the presentation along with the supporting materials that Steve is going to be referencing throughout the presentation this morning. So please take notes on them if you wish, and if you have questions about those, as Steve talks about them, please do pose those to us throughout the presentation. As you know, for CFPs and CPAs on today's webinar, you may receive 1.5 continuing education hours for attending. And for my attendance reporting requirements, please email me your board ID and the last 4 digits of your social security number if you haven't done so already from past presentations. So if you're new to our webinars, please send the information to me in a timely manner so I can get my reporting in as soon as possible. Everyone also will receive a survey very shortly after today's webinar. Please take just 2 minutes or so to fill this out. It provides us valuable feedback about our presentation. We want to make sure we're providing pertinent and solid information to you throughout our webinars and our advisors forum. So very briefly, an overview about our firm if you're not familiar with us. We were founded in 2010 in Columbia by Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at our firm: estate and special needs planning, elder law, elder care planning, estate and trust administration, asset protection, guardianship, and tax planning, among many others. We have 6 attorneys, 12 staff members in 5 different locations. We're coming to you live here from our Columbia Gateway location. Our mission, as it always been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We focus a lot on education here at our firm, and we do that through a number of ways. Through our planning processes with our clients, we offer over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. We are one of about 60 firms in the entire country that has had our CCP, or Client Care Program, accredited through the Client Care Academy in Boston, Massachusetts. So we're very proud about that. If I can get my screen to go forward, there we go. Want to introduce, it's my pleasure to introduce Mr. Stephen Elville, President and Principal Attorney of Elville & Associates. His work is centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. He's a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients and by creating solutions to their needs through counseling, education, and the use of leading-edge legal technical knowledge. He's very busy. He was last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar. He's a very seasoned speaker, presenting at about 75 workshops, conferences, and continuing education events each year. He was also named to the Maryland Super Lawyers list for a 5th time in 2020 and has had a featured story written about him in Super Lawyers magazine as well. So congratulations to Steve. So along with our caring for clients model, the attorneys and staff of Elville & Associates, we work every day with the ideals of client education, collaboration, and compassion in mind. And you should expect nothing less from us when working with us. And we look forward to being a resource to you today and in the future. So don't hesitate to reach out to us if we can help you with any questions at any time, and be a partner with you in your practice or with any clients or needs that you might have. So without further ado, we're going to get started with a poll today to learn a little bit about how familiar you are with today's topic. So I'm going to go ahead and launch that poll right now. I'm going to get my screen clear here. And that poll is pretty simple. And the question is, how familiar are you with the concept of supported decision making? So I'm going to launch that poll. You're going to see it pop up on your screen. Well, you should. There we go. So please just take a minute to answer that poll. That'll give us an idea of how familiar you are with today's topic. It's a very compelling topic, one that Steve is very passionate about. I know he's looking forward to talking with you about it today. Let's see here. Do we get any results in there? I don't think we got any poll results. Tell you what, if you wouldn't mind, in the little dashboard, why don't you go ahead and just maybe give us an idea of how familiar you are with today's topic. If you're very familiar, if you've heard of it in passing, or if it's all new information for you. That'll get you used to using the dashboard and giving us an idea of your thoughts about today's topic. So it's all new information. All new information. We've heard about it in passing. Somewhat familiar. Heard about it in passing. So it sounds like, Steve, it's a relatively new topic to most people here. Sorry that poll didn't work as it was intended to. But Steve, I think you get the idea that it's a pretty new topic here for everybody, and we've got some information to share. So with that being said, I'm going to turn it over to you, Steve, and have you launch into the presentation.
Thank you, Jeff. And I'm just going to wait for the control of the screen.
Yep, that's going to turn it over to you here.
Just need to have this poll go away. I'll try to get that out of the way there. All right, let's see if I have control. Not yet, Jeff.
Not yet.
There we go. I do now. All right. Well, thank you, Jeff. And good afternoon, everyone. Happy Friday to you. And thank you for taking the valuable time of yours and spending it with us today for this advisor forum. And I hope everyone is safe and well during these challenging times. I like to say this is the second phase of COVID-19 that we're dealing with in business and personally. So stay safe. And thank goodness we are in one of those states that's less affected, but we need to stay diligent as we're learning. So it's my privilege to speak with you. And this is a bit of an experimental topic in the sense that we're trying to be leading edge here, talk about something that I feel is important for everyone to know about, not just advisors and professionals, but something I'm also very passionate about, only because I've been fortunate to have run into some people who are knee deep or neck deep in this topic, and they are really on the leading edge of trying to help people with disabilities to have more choice and have more self-determination. And for whatever little part I may play in that, I feel very privileged. And at the end of this presentation, I'll share some information with you about those people and those organizations that are involved, including a certain project that I'm involved with, if you are so inclined to get excited about this as I am. But today I hope to share with you the basic concepts of supported decision making. It is not currently the law in Maryland, which makes this presentation a little bit more leading edge than we would care to normally do. but it is all around us. It is the law of some of our surrounding states, and it will, in my opinion, come to pass in Maryland. And it is already being practiced in a non-official way, which I'll explain as well. And lawyers and CPAs and other professionals are genuinely confused through no fault of their own about what this means. And there's a lot of fears and there's a lot of myths that are prevalent. So today I'm going to try to clear up some of those things and let you know what exactly this is. There's a lot more for you to learn about. There's a national website for supported decision making. We're going to talk about the United Nations resolution on the rights of persons with disabilities. We're going to talk about all these things and try to make sense of it to prepare you for what I believe is the future in supported decision making. So with that said, and all the ambiguities that we're going to face in this discussion, I hope that you'll walk away armed with and prepared for the future of what it looks like, whether you're an advisor, a trust officer, a tax professional, whatever it may be, that you can recognize these issues and these agreements that we're going to talk about. We're actually going to talk about supported decision-making agreements and get into a little bit of the meat of those in the time that we have. I anticipate that this will take an hour or less, so I believe we will be finished before 2 o'clock, well before then. And if you have questions, please ask them. I also want to thank Jeff for everything he's done to prepare us for today. And he's a wonderful moderator, and he does several of these a month. So Jeff, thank you. And it's okay that the technology didn't work, because that tells us that everything is normal. All right, so let's just move right ahead now. I'm going to get rid of myself here, and let's talk about the overview of today's information. And Jeff, I'm going to minimize my screen because it's blocking some of what I'm seeing. So I'm just going to go ahead and do that. Okay, so we're going to talk about today what is supported decision making and why does it matter to professionals. We're going to talk about a brief overview of the history of supported decision making, and this is by no means going to be a comprehensive history, but just a brief history. Why is supported decision making needed in Maryland? We're going to talk about that. I don't mean to have the definitive answers about why it's needed. I just know in general why I'm convinced it is needed. There are various views and points of view on this. What are the current substitutes for supported decision making in Maryland? And that is a little bit of a misnomer. Most of the time we are looking at supported decision making as a substitute for guardianship and not for other substitutes for supported decision making. But I have framed it in this way for the purposes of our discussion. And what is the difference between supported decision making and guardianship? This is a major, major issue. What is the difference between a financial power of attorney versus a supported decision-making agreement? And how should supported decision-making, or how will it work? And what should advisors and professionals look for, and what should they prepare for? And we're also going to talk about the various agreements. So in your materials, I've included agreements for the District of Columbia, Delaware, Indiana, and Alaska. You should see those. Plus, you should have what I will call, and Jeff was kind enough to print this off, a copy of Article 12 of the United Nations Convention on the Rights of Persons with Disabilities. This is one of the hallmark foundations of supported decision making. So if you have a chance to glance at this either now or later, that will be great.
Steve,
I will go over it in detail. Yes,
Steve,
Jeff.
sorry to interrupt. We're having trouble viewing your screen at this moment. So we can hear you and see you fine, but the presentation is not coming through at this moment.
So let's see what we can do. Jeff, would you like to come in and troubleshoot this very quickly?
Yeah, let me come over there real quick.
So I'll let you take a look at it, Jeff. Now, what I would suggest is that if you still can't see it, that you control the screen.
Okay.
And I will just tell you when to page forward.
Okay. No, don't. Let me try this one more time here, Steve.
And I'm going to hit show my screen, Jeff.
Yeah, try that, please. There we go.
All right, and tell me, Jeff, if I get rid of my own image on here.
You're okay right there, Steve.
Yeah, but that's blocking my screen. So what I'll do is I'll use my hard copy and we'll keep moving here. And I'll just advance the screen. I won't be able to see my own screen, but I'll have my hard copy. All right, so I hope everyone can see what's on the screen now, which is the overview of today's presentation. I apologize about the delay here. And now I'm going to move on to the next screen. Jeff, do we have this?
Yes.
Does everyone see it? Okay. So now, what is a supported decision? What is supported decision making, and why does it matter to professional financial advisors or tax professionals or otherwise? Well, let's start with what supported decision making is not. Supported decision making is not about a financial power of attorney. As you'll see in this presentation, it is an adjunct, or it's an addition to possibly to a financial power of attorney, but it is not a financial power of attorney. It is not a way for a third party to make decisions for a disabled person. It is not about a disabled person giving authority to a third party. It is not about giving authority to a third person to do whatever they deem appropriate. It's not a mechanism by which a person with disability gives up their rights. So what we're talking about here is the preservation of rights. And I'm going to give you an example of that in this presentation. And it is not about adult guardianship. This is a substitute for guardianship. Or even if a person is under guardianship, this is something that can coexist with a guardianship. And in some states, this is allowed, and in some states, it is not allowed. So this is one of the reasons we want to delve further here. But what is a supported decision-making agreement, or what is supported decision-making? Well, it's a tool where persons with disabilities can be empowered to be supported in making their own decisions to whatever extent possible. I'll digress here for just a second. The argument is made that we all, whether we have disabilities or not, that all persons need assistance at times to make our decisions. The concept here for persons with disabilities is that they are no different than any other person in the sense that they need potentially support to make their own decisions. Supported decision making is about a simple written agreement, as we're going to go over here in just a few minutes. It's a formalized authority for the supported decision maker to be recognized. So this is one of the big problems. What if there's all kinds of support for people with disabilities to be supported, but what if there's no recognition of the legal authority of the supported decision maker? We have a problem there. It is an alternative to adult guardianship. And as I just mentioned, it can actually coexist within a guardianship. And I'm going to show you the potential or proposed Maryland legislation that is designed to suggest this. It is a potential addition to a financial power of attorney and advanced medical directive. It is a potential tool, just as I mentioned, in adult guardianship. And it's part of a paradigm shift. Let's talk about this for just a second. If you take the time to delve further into the study of this particular subject and the background of guardianship in Maryland, you'll soon realize that there is, not just in Maryland, but in many states, kind of a paradigm or idea of protectionism, of not allowing people with disabilities to make their own decisions, to have a standard of what is capacity versus a standard of what is incapacity. And what happens is we want to shift away eventually from that paradigm to a paradigm of risk we're going to talk about. The potential for a person with disabilities to actually make their own decisions and take risks, and even if those risks seem to be unwise to others. So this is part of a broadening of the definition of what capacity is, and less of an emphasis of what capacity is not. So we want to have a new world of self-determination for disabled people, whether they are young or old. So let's talk about that for just a second. Supported decision-making is about all people having the ability to have support, whether they are intellectually disabled or not, whether they have dementia, whether they are aged, all of those people, all people, this should apply to. Now, why does it matter to financial advisors and other professionals? Continued. We need to understand the changing world of capacity versus incapacity. This applies, just as I was mentioning a minute ago, beyond traditional notions and viewpoints and definitions of incapacity. There are daily practical applications for financial management and healthcare affairs of individuals that is really the main topic for you today. And there are legal agreements similar to supported decision-making agreements that are already in place. Let's talk about that for just a second. Many of you may or may not be aware that the guardianship industry in Maryland, if we wanted to say that about the legal industry in Maryland, is quite robust. And it doesn't take a whole lot for someone in Maryland to be deemed to need a guardianship, okay? But in a guardianship proceeding, which usually takes several weeks or months, what happens is many times those proceedings go all the way to a hearing, and the individual is either deemed to need a guardianship or not need a guardianship. And if they do need a guardianship, of course, they lose their legal rights by definition. They lose their legal rights to their person under a guardianship of the person, or they lose their legal rights to their property under a guardianship of the property. Well, in many of those cases, it doesn't go all the way to a trial or a hearing. And if it does, even if it does, there are settlements. So in those particular cases, sometimes there are settlements called consent orders. Well, these are legal agreements where the parties, the person who is bringing the guardianship action to take away the rights of the individual, so to speak, and get control of that individual's affairs, and the individual who, let's say, is contesting that guardianship, they come to an agreement. Well, those agreements are called consent orders, and there are other names for those agreements. Those agreements are already being used by by attorneys for the parties in guardianship, because there's a big need to craft those kinds of agreements. So the guardianship attorneys, so to speak, are already using agreements that are not exactly supported decision-making agreements, but they are settlements among the parties that the disabled person has certain rights to be able to do certain things, and then that there are other things that only the person who brought the guardianship proceeding is allowed to make those decisions. So just recognizing that in where you are right now in your particular profession, you may run into situations where a person with disabilities, there was a legal proceeding, a guardianship action, but there has been some kind of a settlement agreement where they do have certain rights to make certain decisions. The formalization of supported decision making will mean that there is an alternative to guardianship. So one of the main things I can pass along to you today is that right now there are not very many good alternatives to guardianship. We have a situation where a person with disabilities can sign a financial power of attorney or an advanced medical directive if they have the mental capacity to do so and they understand the nature of it. And if they can't, there is no middle ground. There's this issue of having to go towards guardianship, of course, which is not desirable, and it takes away the rights of the individual. So the formalization of supported decision making in Maryland and what it's done in other states, it provides an alternative to guardianship in the sense that in the middle, the person with disabilities can choose who they want to assist them with their decisions, and it can live alongside of a power of attorney, as we're going to see. And if a guardianship is deemed to be necessary, depending on the state and depending on the legislation that is passed, then a guardianship can actually contain a supported decision-making agreement where the person under guardianship has the right to make certain choices. So what this is all about in the legal community is adding another tool to the disability and the guardianship world to give people with disabilities the rights to make their own decisions to whatever extent they can make those decisions. Now, our brief history of supported decision making. I first met a young lady named Megan Rusiano at the ARC of Frederick, where we were giving a presentation together. And Megan was presenting on supported decision making. This was several years ago. And I was presenting on adult guardianship. And two completely opposite presentations so that the attendees could hear. But she introduced me to this notion of supported decision making. And she was not necessarily from British Columbia, I don't think, but had spent time in British Columbia, where supported decision making is one of the first places it's one of the first places it ever started. So British Columbia, Ireland, Australia, Victoria, Australia, have supported decision making. And then we have several states that have supported decision making. So to my knowledge, those states include Alaska, Texas, Indiana, Wisconsin, Delaware. I believe Tennessee may have supported decision making, and the District of Columbia. And Maryland has legislation in process. And I say in process because I want to say that, to be accurate, that prior to COVID-19, there was a very strong legislative effort. And you should have this in your materials. I'm going to hold it up here for you to see. And it's at the top, it says number 1 short title. And that is something that if I were you, I would label that as the proposed legislation in Maryland from last year. I don't believe this went very far or was even pushed through the legislature due to various technical problems. But I know that the prior year, Megan Rusiano and Disability Rights Maryland made a very, very strong push to make an impact in Maryland to start the process of awareness for legislators and lawmakers to pass supported decision making. But it has not passed yet, and I believe it's a little bit of an uphill climb of education and awareness because, as you'll see here in these bullet points, we are operating in Maryland under an old paradigm, the paradigm of protection. Traditionally, it's difficult for lawyers and legislators to understand this concept because of a fear of change, a fear of fraud and abuse, the fear that if we don't have this paradigm of protectionism, that bad things can and will happen to people with disabilities, financial abuse and so forth. And of course, that's a legitimate concern and it can't be swept under the rug. But as you're going to see in these agreements, the law can address certain kinds of fears and try to mitigate those while also giving the person with disabilities the ability to take risks and the ability to live their life more fully. I skipped over the bullet point on the United Nations just to temporarily delay that I was going to read you now. Article 12, and you should have this in front of you as I mentioned earlier. This is the United Nations Convention on Rights of Persons with Disabilities, Article 12. And I strongly suggest that you look at the entire convention because it's quite eye-opening. But I'm going to read this to you if you don't mind, for those of you who do not have this in front of you. Article 12, equal recognition before the law. States parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. States parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. States parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. To me, that is the personification of what supported decision-making is all about. Two more paragraphs. States parties shall ensure that all measures that relate to the exercise of legal capacity provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. Such safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will, and preferences of the person, are free of conflicts of interest and undue influence, are proportionally and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review by competent, independent, and impartial authorities or judicial bodies. The safeguard shall be proportional to the degree to which the measures affect the person's rights and interests. And then lastly, subject to the provisions of this article, states parties shall take all appropriate and effective measures to ensure the equal rights of persons with disabilities to own or inherit property, to control their own financial affairs, and to have equal access to bank loans, mortgages, and other forms of financial credit, and shall ensure that persons with disabilities are not arbitrarily deprived of their property. So for those of you who won't have time to review this, I just wanted to make sure I read that out loud. And one last note here on the brief history of supported decision-making. There are all of these various jurisdictions which have implemented supported decision-making in various forms, but reading from one of Disability Rights Maryland's publications, I just wanted to note these 5 bullet points about that all these jurisdictions tend to agree about the following 5 things. That individuals retain legal decision-making authority. So this is not about someone else having authority to make the person's decisions. The relationship is freely entered into and it can be terminated at the will of the person, the individual. The individual actively participates in the decision-making process. Decisions made with support are generally legally enforceable. And of course, these agreements require witnesses. And those are the 5 things that all of these jurisdictions seem to share in common. So far in this presentation, I hope that what you're hearing is that there's a strong push in the disability community for people with disabilities to have self-determination and to expand beyond the traditional paradigms of an attitude or an approach of protectionism. All right, and I touched on this before, and if you'll bear with me, I'll repeat myself a couple times here for emphasis. Why is supported decision-making needed in Maryland? Well, as I mentioned, there's no good alternative to guardianship versus a power of attorney. There's no middle ground. And when we get to the examples, we're going to talk about how maybe your clients or children of your clients or parents of your clients are crying out for this kind of ability to have a supported decision maker. There is no formalized way for a person with disabilities to be supported. There is no annual review of private guardianships. Now, I know I'm throwing a lot at you here very quickly. This is a lot of dense material, but I want you to think about this. For public guardianships, they are reviewed annually. For private guardianships, there is no annual review. So the problem there is that guardianship is much more permanent than it really should be. And there's no mechanism under the law, and I'll mention briefly, very lightly, a case that's currently going on in Maryland where someone who should not be under a guardianship, someone who is, this is not a case I'm working on, but I know another attorney, and Disability Rights Maryland is working on this case, where this person is clearly competent and supports themselves and works at a hardware store and does not need a guardianship, but it is a private guardianship, and there's no clear way to end that guardianship under the law. There's no review, there's no annual review, and this particular person is strongly advocating to terminate the guardianship that is not needed and to have her rights restored. So this is a very important case that's going on right now. I'm not at liberty to discuss it any further, but as it's an ongoing case. But this just illustrates that there's no formalized way for people to be supported other than through guardianship, and that there should be. There's no clear way for all alternatives to adult guardianship to be explored and implemented. So let's go back to the guardianship process for a moment. And I apologize for those of you who may not be familiar with the guardianship process. But what's supposed to happen in guardianship is that it's supposed to be the last alternative. There is supposed to be a review of all potential alternatives before guardianship is implemented. And the truth is, we know in the legal world that is simply not the case. So there is no mechanism for alternatives to guardianship to be fully explored and exhausted before a guardianship is implemented. With supported decision making as part of the law, there would be an automatic review of all alternatives to guardianship, including supported decision making as a substitute for guardianship before a guardianship is implemented. This goes to the issue of the next bullet point, which is inconsistency in the judicial application of existing law. So way beyond the scope of this discussion today, let's just say that courts do not uniformly apply the current law. They do not explore all alternatives to guardianship, and neither do attorneys that are involved in these guardianships. And the rule that was personified in a ruling called In the Matter of Sonny Lee, where the person under disabilities, several years ago, this was a ruling where the person under disability is to be treated for purposes of the guardianship as if they were competent. If they decide that they want to contest a guardianship, the rule in Sonny Lee is not being consistently applied. Old notions of traditional guardianship and inequitable treatment are no longer needed. This is subject to controversy, but this is one of the reasons why I believe supported decision making is needed. And again, the culture of paternalism and minimizing risk actually hurts the person with disabilities, and it hurts their potential and their ability to take their own risks and have a life of self-determination to whatever extent they are able to do so. Now, what are the current substitutes for supported decision making in Maryland? This is a little bit of a misnomer, as I mentioned. So don't take that title to this slide too seriously. What I'm just saying here are what are the things that are available outside of supported decision making in Maryland right now. Well, we just discussed this: appointment of financial agents under a financial power of attorney, appointment of healthcare agents under advanced medical directive. Now, what do we know about those two bullet points? We know that if someone has an agent under a financial power of attorney, we know if someone has an agent under a healthcare power of attorney, or healthcare advanced directive is more accurate, then we know there is theoretically no need for a guardianship. That this person has, they have crafted their own private agreement and their own management of their own affairs privately without a guardianship. So a financial power of attorney that has agents is a substitute for guardianship. An advanced medical directive with healthcare agents named is a substitute for guardianship of the person. Representative payee status, so someone who, for example, an 18 or 19-year-old with disabilities or someone older who is receiving SSI, for example, they usually or many times have what is called a representative payee, the person who is accountable to Social Security for this money for the benefit of the person. That is a substitute for guardianship of the property. So for an 18 or 19 or 20-year-old, let's say, that is getting SSI, they have no other assets in their name. They don't need a guardianship of their property. But they may be able to sign a power of attorney. They may be able to name a supported decision maker. And so this is where the discussion today is. Joint ownership of financial assets. We don't need a guardianship. We don't necessarily need a supported decision-making agreement. But the person who has joint assets with someone, they don't need a guardianship, but they could name a supported decision maker to help them with their assets. They could, if they have the mental capacity to do so, sign a financial power of attorney. On the healthcare side, surrogate decision making is a substitute for guardianship of the person. It is a way for spouses or children or other relatives down a list of priority to make decisions without the need of an advance directive, even though the advance directive really should be part of everybody's estate plan. So surrogate decision making is part of the law now, where a surrogate, let's say a spouse, can make healthcare decisions for another spouse, even if that spouse that's ill has not appointed an agent, okay? But even though supported decision making exists, that spouse, if they were disabled, still could have a supported decision making agreement. They still could have a financial power of attorney. Hopefully what you're seeing from these bullet points is that there's all kinds of potential for substitutes for guardianship. And then of course we get to the actual guardianship of the property, guardianship of the person, as we already mentioned, and consent orders, which we just talked about in the beginning of the presentation, which are settlement agreements. Okay, so in no part of these, nowhere in this list do we really see anything that would suggest that a person who is relying on these substitutes for guardianship could not have, even if they did have a guardianship, they could, whether they do or not, they still could have a supported decision-making agreement, depending on what the statutory law is of the particular state. Jeff, I'm going to stop just for a second to take a sip of water and make sure that we're on time here. Do we have any questions so far?
Right now, Steve, no questions.
All right, I know it's a lot of dense material. I promise that we're going to continue and it will hopefully become clearer. So what are the differences between supported decision-making and adult guardianship? Well, in adult guardianship, as I mentioned, we have a removal of rights to a person's property under a guardianship of the property. Under an adult guardianship of the person would not be able to choose their place of abode or usually have any real decision-making authority, with some exceptions about health care. The person would typically lose their right to vote unless the petitioner specifically asks to maintain the right to vote. In essence, they have no legal choice, okay? And again, this is the paradigm of protectionism, which is an issue of some controversy and debate. It does not recognize generally the right of the person to take risks. And there's a fear of failure. There's a fear that if this person has the right to take risks, that bad things will happen. And as we know, and I just mentioned, there's no private review of these adult guardianships in private guardianships. And then again, there's this unspoken consensus of permanency. And this goes back to my example of the person right now who's an older adult who's competent and is no longer disabled and is seeking the termination of a guardianship against a lot of resistance, because guardianship tends to be permanent when it should not be. Now, what is supported decision-making compared to adult guardianship? Well, there's no removal of rights. And as I just mentioned, in that particular person's situation, there is a potential for the restoration of rights. And this is just a pretty daunting thought. How many thousands and thousands of guardianships have there been in Maryland that are private that are never reviewed, and they are never again reviewed for the potential of the restoration of a person's rights. That's a pretty scary thought. The rights to property and person in a supported decision-making agreement remain vested in them. They are vested in the individual. They are not vested in a guardian. And now we are talking about a paradigm of individual risk, giving the person the right to fail, which is pretty scary in some ways, but not something that couldn't be addressed, as you will see in some of these agreements. And as I mentioned, the supported decision-making agreement can actually be part of a guardianship, and it can be in addition to a financial power of attorney. So what we're really talking about here is helping a person with disabilities make as much of their own decisions, or as many of their own decisions as possible, to whatever extent possible. And I think the argument could be made that persons with disabilities should and can make their own decisions to whatever extent society is willing to help them to be supported in those decisions. And I think what it comes down to is the willingness of our society or of our state to be willing to help support people to make their decisions. Now, I'm going to digress to financial powers of attorney now that we know what a supported decision-making agreement is versus a power of attorney. So in a financial power of attorney, the agent acts on behalf of the principal, the person who named them. And the principal, the person who is naming their agent, gives the agent certain powers. They determine when those powers become effective. And the agent acts when the principal cannot act themselves. So you see the difference. I'm just trying to really emphasize that, because this is a very confusing thing for some people. The supported decision maker under a supported decision-making agreement helps the disabled person make their own decisions, does not speak for that disabled person. Whereas in a financial power of attorney, the agent acts when the principal or the disabled person can no longer act for themselves. There is fiduciary responsibility for an agent under a power of attorney, and they are accountable, of course. Their authority and their agency can be terminated by the principal. It must be terminated in writing. And of course, as I mentioned, the financial power of attorney is a substitute for guardianship, mainly a substitute for the guardianship of the property. Now, as compared to a supported decision-making agreement, there is no agency relationship per se in the same sense. The power of the principal remains vested in the principal. Now, again, for those of you who are trying to follow this, and I want to make very clear, remember, a person could have a financial power of attorney and a supported decision-making agreement. The financial power of attorney is used when the person can no longer make their own decisions. The supported decision-making agreement is used when the person is trying to make their own decisions or needs help in making their own decisions during life. This applies also to the healthcare side of things, healthcare decisions, but here we're talking about financial decisions. Third bullet point, the principal alone makes decisions. This is the supported decision-making agreement. The disabled person, with help of the supported decision maker, makes the decision. There is no authority for supported decision makers to act or to speak on behalf of the agent. Now, this is something that is tweaked a little bit between jurisdictions, but generally speaking, there is no authority for the supported decision maker to speak for or act for the disabled person. There is accountability depending on the jurisdiction. To the extent of the accountability depends on the jurisdiction. There are monitors and so forth, as we're going to see in the agreements. The supported decision maker's role can be changed or terminated, and of course they can resign at any time. And supported decision making is also a substitute for guardianship. What I would like to emphasize, it's not meant to replace guardianship. It's not meant to replace financial powers of attorney or healthcare directives. This is another tool in the toolbox to give people with disabilities more choice. Now, we've been going for about 35 to 40 minutes, and I think we're on time. Let's talk about how supported decision-making will work when it does come to Maryland, and what should professional advisors look for and prepare for. So hopefully I've laid the ground for you to see at least some study material to get familiar with, because this is a very strange concept for those of you who have not been initiated to it. So there are formalized agreements, and we're going to take a look at those in just a second. And remember, there are already formalized agreements in guardianships, and some of you may or may not have run into this, but we're going to be in a world in the future where people with disabilities may be people who have very significant assets. We already know that people with dementia and other illnesses that are generally age-related, but not always, we know that many people have accumulated a lot of money, and their accounts, they have all kinds of issues going on. As professional advisors, you're going to need to be able to recognize a supported decision-making agreement, which you will not have any problem doing that, and you're going to need to learn to deal with the supported decision maker who is part of that process. Now, this gets to the next bullet point, which is that disabled persons will present someday with their supported decision maker. I have clients right now whose children are now of the age of majority, and because there's no formalized supported decision making in Maryland, they are going ahead and being proactive to go ahead and have their children sign supported decision making documents, even though it's not really the law yet. So you may see this sooner than we think. So let's look at this next bullet point. The supported decision maker has the right to review all documents or medical records. Okay, so here we have this disabled person that presents in your office or in your line of work, and they bring their supported decision maker. This person has the right to review documents in the thinking and the genre of supported decision making, whether or not, look at this italics, whether or not they are appointed as a financial agent or a healthcare agent under a power of attorney or advanced directives. So by virtue of the supported decision-making agreement alone, they have the right to review financial records or medical records. So that is quite a shift away from the standard of powers of attorney versus guardianships. Depending on the nature and scope of the new law, government authorities such as monitors, and you're going to see this in the supported decision-making documents, monitors may have the review power and the right to information. So not only just the supported decision maker, but the monitor that is installed in some states to look at what the supported decision maker is doing. This is a safeguard, especially on the financial side. And here it says the supported decision maker may or may not be appointed as an agent, as per the first bullet point up there, and therefore they will not have decision-making authority unless they are appointed as an agent with their power being effective in that document. So again, if you do nothing today or take away nothing today from this presentation, remember that a supported decision-making agreement is a standalone document, standing alone from a power of attorney or advanced directive, or if a person does not have a power of attorney or advanced directive, it's a document that stands on its own regardless. So this will happen, and when it does, you will be prepared to deal with this situation when the disabled person and their supported decision maker present to you. Intellectually disabled people and people that are non-intellectually disabled, and whether they are verbal or nonverbal, persons with dementia and the aging population and any other variety of persons that need support, all of these people may present with a supported decision maker, and that supported decision maker is entitled to information, and the person needing support is entitled to support under the law. And this last sentence, I think, is very important. This will likely include persons who appear or present severely impaired and unable to formulate and express their own desires. So taking supported decision-making to its conclusion will basically mean that even severely disabled persons, or persons who appear to be severely disabled, or persons who cannot seem to express themselves in traditional ways, those people still should be considered, depending on the jurisdiction, as having the right to make their own decisions and express their own self-determination to whatever extent possible. Recognize that supported decision makers may find themselves in difficult situations. So imagine the supported decision maker, and I know many people right now who are really the supported decision makers, and I know you know people who are like this. They're doing a wonderful job supporting the person with disabilities, enhancing their lives, using their special talents to do this important work. But even though they're not formalized and under the law, they should be. And when it's formalized, the supported decision maker may find themselves in very difficult spots, presenting to you, with you, and trying to help the person with disabilities make their own decisions, their own financial decisions. It's not an easy job, as you can imagine. Supported decision makers will likely not be paid staff of the disabled person. And I put here that this is for better or for worse, because there are arguments on both sides of this coin that the person who is being a paid caregiver, the problem is this is the person who's most logically, who most logically should be the supported decision maker for the person. And yet many states prohibit a paid caregiver or a paid advocate from being the supported decision maker. So this is a problem because the person with disabilities generally does have their life enhanced by this person and generally depends on this supported person or this advocate that's non-official. And now that person is prohibited, let's say, in many states from being the supporter. So this is one of the things that's being argued and makes this a difficult law to pass, even though I think it will eventually pass.
Steve,
Yeah.
have a question before we go into the agreements. Stepping back just slightly, we do have a question. The question is, what is the process of obtaining a private guardianship versus a public guardianship? Do they both require a court hearing?
Yes, so the processes are always going to require a court hearing, and they're always going to require proof of disability as evidenced by two physician statements. And again, the nuances of the words capacity and incapacity, disability and capacity are academic terms that need to be tossed about, and their definitions, according to the law, are extremely important as to determining the rights of an individual. But generally speaking, the processes are going to be similar in the sense that the person must be disabled. There is no less restrictive alternative, meaning in simple terms, there are all alternatives to guardianship have been explored. And of course, we know that that is not the case. All potential alternatives are not always explored. And one of the arguments of the advocates, the attorney advocates for supported decision making, is that if we had a formalized supported decision making law, there would be this automatic mechanism where every person who has a guardianship filed against them, so to speak, they have recourse to be able to appear, which they already do, but there would be a reason for them to appear in a more formal way to basically say to the court, I have the right to have a supported decision maker, have all potential alternatives to guardianship been explored. And in some of the more progressive states, all of these potential alternatives to guardianship are required to have been explored and fully exhausted before there is a guardianship. But the answer is yes, that when a person is deemed to need a guardianship or be a ward under a guardianship, the standard of proof is the same. All right, so let's get to the review of supported decision-making agreements. And
one more, Steve?
Yes.
Okay. Interesting question. The question is, I had a surrogate, in quotation marks, a surrogate decision-making authority letter drawn up by an attorney back in 2013 for my autistic son who is severely disabled from a decision-making standpoint. It references its legality under Maryland Health General Code 5-605A24. The form was signed by me and my wife and notarized, and states that we as the parents have the authority under Maryland Health Decisions Act to make healthcare decisions for him. Does this form, quote, stand, unquote, on its own as regards to Maryland law?
Thank you for that question. So that's a great question, and I'm going to say that I don't have the code in front of me that you're quoting there, but generally speaking, if I understand your question and what happened correctly, the minor child, there was an agreement signed that basically just formalized your right to make decisions for that minor child for their health care. And I would say, first of all, my initial reaction would be, you have the right to do that regardless of that particular surrogate decision-making agreement. I'm not saying that was the wrong thing to do, but you have that right because you are the parents of that minor child. So you are the guardians of that minor child, so to speak, and have the right of decision-making anyway. But the reason I think that that was a great idea, notwithstanding all of that other stuff, is because when that child becomes 18, if the child is much older now, I'm not sure, when the child becomes 18, you are the surrogate decision makers of the child anyway. Again, you were the guardians of the minor child. When the child becomes at the age of majority, you are the surrogate decision makers. And many times people forget, or they forget, they don't know at all. They don't know anything about surrogate decision making. So this is a great point, that when I said that there's no good alternative between powers of attorney and guardianship, if you remember back to a slide we had several slides ago, we did mention surrogate decision making. So that is a potential substitute for guardianship on the healthcare side. So I think by having that formal agreement signed, you're basically saying to the world, we may or may not ever be our child's agent under a financial or power of attorney or healthcare directive. We may not have our child may not ever sign a supported decision-making agreement, but we have not forgotten, and no one else should forget, that we are the surrogate decision makers for our adult child at that time, regardless of whether they have an advance directive, regardless if they, so surrogate decision making is healthcare related, and my point of that is to say, I don't think it was a bad thing to formalize that, even though that does not necessarily mean you don't need a guardianship of your child at 18. It just means that you're getting the world to recognize that there is such a thing as surrogate decision making, which not all states have.
Okay, thank you, Steve.
All right, so I'm just going to say that wasn't such a bad idea, even though I'm not sure it was needed at age 13. It's not a bad idea to have that formalized. Okay, so now I'm just going to hold up these agreements in the interest of time. I promised to end in an hour, and I promised to try to do that. The one I'm holding up now is the Indiana Supported Decision-Making Agreement, to the best of our knowledge. And you'll see some information here about Indiana code. And one of the things you'll see here is at the bottom of this first page, I want to have people I trust help me make decisions. I understand that I can talk to an attorney. I understand this agreement because I want supporters to help me. You see, these are pretty straightforward agreements. And on the next several pages, you'll see in the Indiana model that there's lots of space here for the person to make all kinds of entries and customize their supported decision-making agreement. As I go towards the back of this agreement, I see here that there is a list of supporters, okay? And it says, I understand that certain documents may give my supporters more authority in my life or access to my personal information. One of the things that I would point out to you is some of these documents are going to cause ambiguity in your mind. So I think institutions, broker-dealers, law firms, all kinds of people are going to be in different circumstances interpreting the nature of these documents, which means it's more important than ever for the state to formalize what this is all about. So in Indiana, I strongly encourage you to Google Indiana supported decision making, because they have in my mind, they have a wonderful system in place with lots of education and lots of online information that you can review. So as you look through these various agreements, you'll see how different they are. On the very back of the Indiana agreement, this is the supporter signing their consent. I consent to act as supporter for the person. I know I may not make decisions for the adult. I understand that my job as supporter is to honor the express wishes of the adult, and you get the flavor of this particular thing. As a supporter, I am prohibited from exerting undue influence on the adult, receiving a fee for service, and so forth, and there are certain limitations. Indiana, I wanted you to have that for your records. This is Delaware. So right next door to us, we have Delaware. I hope you can see me on the camera, but the Delaware agreement is much more succinct. And as I look down through this agreement, I see Delaware code. I see the name of the supported decision maker, the name of the principal. And then as we go further, as you read the check the box choices about what support the person wants, at first I think we're all taken back about how simple these agreements are. Look at this on the bottom of page 2. Areas I do not want my supported decision maker to help me with. So this is where a person can articulate those things. Again, this is signed and witnessed, and it has to be signed by the supported decision maker who acknowledges it. And if you read the Delaware agreement closely, it seems to suggest that Delaware will not allow a supported decision-making agreement to be part of guardianship. So you'll see that there are different elements. To my knowledge, Delaware was the first state to implement supported decision-making. I want to show you briefly the Alaska version. Jeff was very kind to research this, and Jeff pointed out to me that the Alaska agreement, and we've spoken to some people from Alaska, and we also would recommend the Alaska Supported Decision Making website as also another excellent resource for you. This one seems to be a conglomeration of many types of guidance for the person who is formulating the agreement. And according to Jeff, it appears that Alaska does not have a set form for supported decision making, but instead goes to great lengths to help a person work through. It could be with their advocate, it could be through their attorney or other advisor, to work through and formulate their own supported decision making agreement. So as you see the back of the Alaska agreement, you'll see many links to where you can become more educated about supported decision making. And lastly, in the interest of time for these agreements, I wanted to show you our neighbors to the west. The District of Columbia has its own supported decision-making law. So here we are surrounded by Delaware, DC, and we are lagging behind here in Maryland to have our supported decision-making law. So the DC agreement tends to be very, very explanatory. What is a supported decision-making agreement? What is supported decision-making? Who can use the statutory supported decision-making forms? Who can and who cannot be a formal supporter? And so forth. In these forms, for example, in DC, there will be a monitor. And here we have the actual agreement on the back of this, the supported decision-making agreement. Very, very simple and easy to understand. And here's something that's important that reiterates what I said earlier, and this is in the DC form. Nothing in this document prevents my supporter from also serving as a power of attorney or a healthcare decision maker. So you see, this is not a one way or the other thing. This is an inclusive tool that can be used with powers of attorney and so forth. And of course, it has to be signed and witnessed and notarized and so forth. So I hope that's helpful to you to start the process of you becoming more familiar. The last thing I wanted to point out before we get to examples is the Maryland proposal. Now, The folks at Disability Rights Maryland don't know that I'm showing you this, but I'm sure they would be very happy for you to see what is being proposed or what was being proposed. And as you read through this Maryland proposal, which is not law, you'll see that it does contemplate the ability of a person to enter into a supported decision-making agreement, even if they are under guardianship. I'll read it to you. An adult may not enter into a support decision-making agreement under this section if the agreement supplants the authority of a guardian, unless the court amends the guardianship order to allow the adult to enter into a supported decision-making agreement. So this would be a wonderful beginning for Maryland if this legislation was passed, which again, my understanding is last year it was on hold, but I think that Disability Rights Maryland and Megan Ruciano and others are ready to move this forward. As we wrap up, I'm going to talk about examples now. None of this is extremely complicated. Once you start to understand the basic concept that supported decision-making is basically allowing a person with disabilities to make their own decisions to whatever extent there is possible with the help of a supported decision maker. So many of you are experiencing this in your practice. I know we experience it at Elville and Associates. Parents with disabled child turning 18. This is a wonderful way, a wonderful time for this family to be able to have their child enter into a supported decision-making agreement if it's appropriate. Parents with older adult disabled child. So what if there is a child that's much older, that it may even be nonverbal, the child may be, whatever the level of disability is, depending on the statute that is eventually passed in Maryland, can this person make some of their own decisions? And if so, do they have the support to be able to do so? Can they name a supported decision maker and sign an agreement? Many people can when we start to think in terms of letting them take risks rather than the paradigm of protectionism. As I just mentioned, a person who's under guardianship, depending on the jurisdiction, can appoint a supported decision maker even if they're under guardianship. A person currently under guardianship should be able to appoint a supported decision maker, as you just saw in the, I apologize, I'm going to go back and clarify my prior bullet point. A person who is subject to a guardianship action, a person who is in the process of having a guardianship launched, so to speak, against them to take away their rights, they should be able to say, hey, there should be some lesser restrictive alternatives. Supported decision-making should be one of them. And then, of course, the person who is currently under guardianship, depending on the jurisdiction, should be able to get the permission of the court to appoint a supported decision maker. A senior adult, and we know how much senior adults generally want to keep their independence. We know how many painful discussions there are about trying to get guardianship for an adult who has dementia or other problems. This can potentially avoid the leap into guardianship and all the heartache that comes along with that by allowing this person to make more of their own decisions. Again, supported decision making is not to take the place of guardianship. There are many times when guardianship is absolutely needed, and we all know that. Disabled person needs help with personal health care decision making. That's the essence of supported decision making. The disabled person needs help with their financial decision making. That's the essence and thrust of supported decision making. Now, Jeff, I'm going to open it for questions and answers. If anybody has any more questions, and I'm also going to end on the following slide just to show if anyone is interested in getting behind the supported decision making movement or to advocate for it. And regardless of that, I'm hoping today gave people a good initiation into what is going on in the world of supported decision making.
Well, thanks, Steve. I think that slide that you were hoping to end on might have disappeared.
Well, I'm back to questions and answers. I'll put up this last slide, but I just wanted to give people a chance to ask questions.
Sure. Yes, we have one. So the question is, that just came in a minute ago, if I established a special needs trust for my special needs son with me, my wife, and my daughter and successor trustees, Is there a need to consider a supported decision maker agreement, or is the trust a cleaner approach?
That is a wonderful question. Thank you for that question. My answer to that is this. The answer is yes, there is still potentially a need for the supported decision-making agreement because the special needs trust, remember, is a mechanism to protect the child's benefits. If the child has means-tested benefits, such as a waiver program or Medicaid under SSI and other means-tested benefits, the special needs trust is also to enhance the life of that child. But the child themselves, the question is, once they turn 18 generally, the question is, who will have the authority to make decisions for them? Let's say they need help with decisions because they are not capable of appointing a supported decision maker. So maybe there is a need for an adult guardian. Or if there's really no need for a guardian, then the question becomes whether that child, what happens if something happens to you? Who is going to take care of them and manage their affairs as their agent under a power of attorney or as their healthcare decision maker under an advanced medical directive? And so it's a question of their vulnerability. It's a question of their capacity. And the question is, will there be a legislative effort and a law in place that the child can appoint a supported decision maker, even if they don't have the mental capacity to sign a financial power of attorney? So my point of that answer is the special needs trust takes care of the child's needs in the future and preserves their public benefits or means-tested benefits, but the decisions about the child's health care and financial affairs is still a question about who has the authority to do that now that they are an adult, and whether that child needs a guardian, and if not, giving them the right to take risks and make their own decisions with a supported decision maker, or if they have the ability to sign a supported decision making agreement and a power of attorney and advanced directive.
Thank you, Steve. Any other questions?
All right, I know that was a lot of information. I was a little bit up and down and all over the place about the law and trying to emphasize certain points. Hopefully it made some sense. And if you have questions, I hope you will ask and let Jeff know, let me know. Megan Rusiano and Disability Rights Maryland are champions of people with disabilities. National Supported Decision Making does have a website. The ARC of Maryland and the National ARC are advocates for supported decision making. I myself am working with Megan and Disability Rights Maryland to use my firm's studio to do a documentary on, this is an ongoing project, on supported decision making, and that film is called Championing the Voices, and we are hoping to change the hearts and minds of lawyers and legislators, and a lot of people are enthusiastic about our efforts, and if you would like to know more information about this, I'm happy to let you know, and we certainly do need all the help we can get. So with that, I want to thank you for wading through all of that information with me. I hope it provided some background. And for you professionals that are on the call, I'm hoping that it prepares you for the eventualities of supported decision making and any substitutes for guardianship other than supported decision making that may come along. I think you will find that by knowing about this, you'll be able to talk to your clients and people within your sphere of influence, and you will be on the leading edge of what's happening for people with disabilities, which is quite a broad topic, whether they be intellectually or non-intellectually disabled, whether they be someone with dementia, whether they be someone who is just aged, across all the spectrum of disability. Thank you and have a wonderful weekend. Jeff, I'm going to turn it back to you.
Well, thank you, Steve. Had a few comments here. Very interesting topic from some of our good friends that attend a number of our sessions here. So thank you. Thank you, everybody, for attending our advisors forum. Let's give a virtual hand to Steve, as we always do, for a job well done. And topic that Steve's very passionate about. I learned a tremendous amount just now, so I was I'm very intrigued by it. Listening to Steve, and special needs planning is certainly an area that we're very passionate about here at Elville and Associates. Uh, Meet some of the most wonderful families, as I'm sure you do in your practices as advisors. So let us know if there's anything we can do to be a resource to you in any way, as always. So just wrapping up, if you have any final questions, please now's the time to pose those to me so I can get them to Steve. Right after the webinar is over, you're going to receive a survey. Please give us your thoughts. Let us know what your thoughts are about supported decision making, any other things about the webinar that you really enjoyed or wanted to know more about. You can always email Steve or myself, and we can get that response to you. All of our webinars, not just our advisors forum now, are available for continuing education credits for our financial advisors, our CPAs, our certified senior advisors that are on the webinars. So we have a number coming up in August. So make sure you check out our website, and I'll be sending invitations out about those as well. And we look forward to seeing you on another one soon. And hope you have a great weekend, unless there's any more questions. So I'll give it just a few more seconds here. And, I think we'll call it a wrap here, Steve. So thank you very much. Thanks, everybody. Have a great weekend. Take care.